So how did the changes to the Indiana Criminal Code come about? First, a little bit of history. Beginning in 2009, the state of Indiana began studying its criminal law in more depth. Some of the issues that came to light were the expense of rising prison populations, the large number of people in the prison system who are drug offenders, the severity of sentences for nonviolent offenders. A lot of people started to point out what were believed to be inconsistencies between nonviolent drug offenses and violent offenders who were receiving sometimes less time in prison. The result is that House Bill 1006, the 2013 version, and also the 2014 version of House Bill 1006, caused many changes to the criminal code. Most of those changes started July 1, 2014. Some start later, and a few started before that. And we're going to go more in depth.
The old criminal statute divided felonies by classes. So you had murder as a separate felony class, and then you had Class A, Class B, Class C, and Class D felonies. Misdemeanors were divided much the same way, and that has remained unchanged. The old criminal code had a sentencing range for murder that was 45 to 65 years, and the new statute has kept that unchanged. Class A felonies used to have a sentencing range of 20 to 50 years, but Class A felonies are now designated into two levels under the new code. So you have level 1 felony that has a 15 to 30 year sentencing range, and then a level 2 felony that has a lesser range of 10 to 30 years. What was known as the Class B felonies that carried a sentencing range under the old code of 6 to 20 years are also divided into two new levels of felony. So you will have a level 3 felony that has a 3 to 16 year sentencing range, and then a level 4 felony that's slightly less that has a 2 to 12 year sentencing range. Class B felonies are now known as level 5 felonies with a sentencing range of 1 to 6 years, and Class D felonies under the old code are now known as level 6 felonies, which carry 6 months to a 2.5 year sentencing range.
And just to give you an idea of how the new sentencing range is viewed, you have to understand advisory sentence. Advisory sentences are essentially a guideline for the court. Before there were advisory sentences, there were presumptive sentences, and under the old presumptive sentence system, a court had to explain any deviation from that presumptive sentence. And then advisory sentences became suggestions where anything in the range is appropriate, but the advisory sentence still needed explanation if you were going to change from that. And with the new law, the advisory sentence is even more attenuated. You might say it's even a weaker idea. It's simply throwing out a possible, it's often in the middle of the range. And so if you just look at the advisory sentence, you see, for example, and it is unchanged in murder, but with A felonies, the advisory sentence moves into level 1 felony remaining at 30 years, but the level 2 is down to 17.5. The two that are split out of the former Class B felony are levels 3 and 4, and those both carry a lower advisory sentence. The new level 5, which was the former Class C, is just 3 years, and the new level 6, the former Class D felony, is just down to 1 year. And so that kind of gives you an idea how the sentencing range and the advisory sentence within that range have both become somewhat more lenient under the new sentencing scheme.
So I had said earlier that misdemeanors are not divided into levels of offenses like felonies are. So what you will see under the new code is that crimes referred to as numbers like 1 or 2 generally correspond with felonies. crimes with letters, like B or C, correspond with misdemeanors.
Credit time is an important idea in criminal sentencing, and it's certainly still a very important idea under the new sentencing scheme in Indiana. Credit time simply gives offenders an incentive to behave while they're incarcerated. It's been in criminal law for a long time. Indiana has two types of credit time. One is good time credit, which is behavior-based, and the other is earned credit time, which is, broadly speaking, educationally based. Both of those things changed pretty significantly in July of 2014 in Indiana, and we're going to talk a little about those changes.
The old criminal code divided credit time into classes. So you had class 1, 2, 3, and 4. Class 1 had 1 day for each day served, and under the new criminal code, that's referred to as a Class A credit time, which has remained unchanged at 1 day for every day served. And then the old code that had 1 day for each 2 days served, which was a Class 2, is now changed to a Class B, but rather than having 1 day for each 2 days served, you have 1 day for each 3 days served, so you'll receive less good time credit time than you did under the old code. Class 3 credit times were no credit time earned at all, and under the new criminal code, Class 3 is known as Class C, and that does give some credit time. There's 1 day credit time for each 6 days served. The old code had 1 day for each 6 days served under the Class 4 structure. However, under the new statute, Class 4s are known as Class D credit times, and there is no credit time earned as a Class D.
And it's easy to get confused over this. Don't confuse the classification of credit time with the definition of felonies or misdemeanors that we described a moment ago. For some reason, the code changes from Roman numerals to letters in describing how an individual offender fits in the classification of credit time. But that has nothing to do with the names of the now felony levels or misdemeanor classes. So don't confuse that. You can be charged with a level, a certain level felony, and be in class, A or B for purposes of good time credit. Don't let that confuse. That A or B does not correspond to the misdemeanor charge. So I think that, frankly, may add to some confusion down the line, but most people don't even know that these definitions are given classes. They just know, for example, I'm getting day-for-day credit, or I'm getting 3-to-1. So Class A is available only for level 6 felony and for misdemeanors. Class A is the most advantageous class for an offender, because the new Class A is the most credit you can get, 1 day credit for each day served. Most felony charges will now start at level B, and that's highlighted in red under the new column. That's the single biggest change to the good times credit structure, is that most felons will not receive day-for-day credit as they had under the old scheme. Most convicted felons will receive just 1 day credit for every 3 days served. Another change that is in the statute, I think it had been determined by case law, but it's in the statute now, is that home detention is still eligible for good time credit. There was some struggle over the last several years with courts knowing how to credit home detention resolved by statute. So let's look at a couple of examples.
Let's say we have a person named Jason charged with stealing $55,000 worth of gold coins from a pawn shop. Under the statute, he would be charged with the crime of theft. The value of the coins at $55,000 makes that theft charge a level 5 felony. If he pleads guilty to the level 5 felony, he would receive an advisory sentence of 3 years under the new code. Under the old law, with his jail time credit, he would be out of jail in 1.5 years. So he would serve half of what the advisory sentence says on paper, because he would get 1 day credit for each day that he served. However, under the new law, he would serve in jail 75% of his sentence instead of 50%. So he would actually end up serving more time in jail, we call that an executed part of his sentence, than he would under the old code.
And it's not that he would receive the advisory sentence necessarily. We're just choosing that as an example. He would, of course, could be sentenced to anything under the range of the level 5 felony, but we're just using the advisory sentence as an example, and under the old one, if he got the 3 years, the new law is advisory. And so the point in this is that even though the sentence range and the advisory sentence calls for a more lenient or shorter sentence, most offenders will have to serve more of that sentence than they would under the old determination, or than they would under a larger percentage of the sentence, not necessarily a larger sentence in net, but a larger percentage of the new sentence. So it gives offenders a more lenient sentence, and then it turns around and often makes them serve more of it than they would under. The second concept is earned credit time. This is the educational credit that an offender can receive. There's under the old scheme, there was a cap on an educational or rehabilitation credit of 4 years, or 1/3 of the total credit time, whichever is less. That cap is now going to be 2 years, or 1/3 of the total applicable credit time. Another small change is that there was a maximum 6-month credit for vocational technical training. That's been raised to 1 year. An offender can receive a larger voc or technical training credit max. The new law also limits education programs as those likely to lead to employable occupations, as determined by the DOC and Department of Workforce Development. And that may eliminate some college opportunities for people who wanted to earn degrees in maybe the liberal arts or some of those things. And I was a liberal arts school attendee, so I'm sympathetic, but I think you'll see some educational opportunities scaled back a little bit, and offenders given either fewer choices or choices that are more directly related to employable occupations and vocational technical training.
I think it's important to note here, too, with the earned credit time and educational discussions, is that traditionally, if you had a college student who had a year or two or maybe a couple of semesters under their belt, and then went to the Department of Corrections for some type of criminal offense, they could still earn educational credit while they finished up their degree or continued with their degree in the Department of Corrections, but that is called into question now under the new code, and it looks like the full amount of credit cannot be earned unless a person is starting their education while in the Department of Corrections. Suspended sentences are important because suspended sentences are the amount of time that people are able to not be in jail. So what you'll see a lot of times is in plea agreements or sentencing orders, you'll see a sentence like 1 year at the Department of Corrections with 6 months suspended. That means that 6 months of that 1 year sentence do not have to be served, and usually that's a great thing. Suspended sentences usually result in probation rather than jail time. And the general thought process behind that is that the threat of prison or jail, if probation goes wrong or if there are any subsequent criminal charges or anything, provides an incentive to people to behave and to complete their probation successfully. The new law gives the courts more freedom to suspend sentences. So there are more criminal offenses under the new statute that can be suspendable. However, Murder and level 1 felonies are restricted in terms of the amount of suspended jail time, or any situation where there's a prior unrelated felony conviction, if we're talking about a level 2 or a level 3 felony.
Since drug crimes were one of the key motivators to the changes in the Indiana Criminal Code, I want to examine in particular how drug crimes will be charged differently under the new law. As a general rule of thumb, drug crimes that involve small quantities have been reduced to lower felony levels. As you can see here, the move from the old to the new sentencing system with the advisory sentence, again shown in red, results in lower advisory sentences, lower ranges, generally lower level felonies for these smaller amounts, less than 1 gram, 1 to 5, 5 to 10, but really starts to ratchet that up as the quantity increases.
Look at an example. Arson, under the old statute, the basic offense was a Class B felony which carried an advisory sentence of 10 years. The arson offense would be increased to a Class A felony if there were bodily injury upon another person or serious bodily injury to another person. The advisory sentences for a Class A felony under the old code were 30 years for both the bodily injury to another person and the serious bodily injury. Under the new statute, the basic offense of arson is now a level 4 felony, which carries an advisory sentence of 6 years, which is 4 years, obviously, less than under the old code. And bodily injury to another person, which was once a Class A felony, is now a level 3 felony, which carries a advisory sentence of 9 years, which you can tell is substantially lower than under the old structure.
Just to give you an idea of how the increased leniency in the sentences is offset by the redefinition of credit time, let's look at this third category, serious bodily injury. As Rachel explained, under the old system, the presumptive, or I should say advisory sentence was 30 years, and now it's been reduced to 17.5. And at first blush, that seems like a much, much more lenient sentence. But when you take into account credit time and realize, well, the Class A felon under the old system could still receive, or at least was eligible at time of sentencing, for 1 day credit for each day served, the new credit time places that level 2 felon in a situation of receiving only 1 day credit for every 3 days served. So assuming in both examples that the advisory sentence was the sentence handed down, you might expect under the old system a person to be sentenced to 30 years and serve actually 15 of it, assuming their credit classification never changed. And under the new system, also sentenced to advisory for the same crime, that would put the person in a 1 credit for every 3 days served, and so you can see the difference of actual time served is less dramatic. There's less time, but you can see here the actual time served is closer to what it was before, and not as dramatic a difference as the advisory sentence itself.
Under the old criminal code, there were a fairly large amount of criminal offenses that did not involve the use of a vehicle that carried a driver's license suspension. Starting in January 15th of 2015, so this coming January, there are going to be driver's license suspensions that are less common. And taking away driver's license suspension that does not necessarily involve the use of a vehicle. You see in OWIs, a lot of times there are driver's license suspensions, but under the new code, The first and second offense will not have a mandatory minimum driver's license suspension. If a person does not own a motor vehicle, under the new code, they won't be required to provide proof of financial responsibility to restate their driver's license suspension. That was a requirement under the old code, and a lot of times it really prevented people from getting their licenses back after a suspension. The reinstatement fee will be increased, and so that could create a barrier for some folks in getting their driver's license back.
Other changes in the law are really too numerous to mention. There have been a lot of substantive changes to individual crimes. In many cases, that is to adapt the old 4-class felony structure to a 6-level felony structure and divide those out. But there are a lot of particular changes. If you have any questions about any of the changes, how it might affect or your loved ones, don't hesitate to give us a call. And thank you for watching.